And so people tend to think if we don't criminalize it, we're not taking it seriously. The best way to send a message is through our criminal law, even though we know in lots of areas, including intimate partner violence, that just isn't true. It doesn't particularly help anybody very often. So that's the first piece. We have this notion that if it's bad, we criminalize it. And people who are bad, they go to court and there's a fair proceeding and there's a righteous outcome and it's good for all of the people, despite all of the evidence to the contrary. But when we're talking specifically about coercive control or slightly more broadly, intimate partner violence, it is a real dilemma. And I think both Lee and I and many others have struggled with this in our work. When I was first practicing law, I saw many women who had been victimized by coercive control. We didn't call it that then. And they would say to me, how come there's nothing the police can do? I call the police and they tell me there's nothing they can do. But if he just smacked me once, they'd be able to take him away. Now, often those women hadn't thought about whether they actually wanted their partner to be charged or not. But to them, the notion that the more psychological, the less physical violence wasn't an offense was a way of telling them it didn't matter as much. It wasn't as serious. And so for those of us, and I think most of us doing this work would fit into this category, we want to honor and respect the lived experiences and the voices of survivors. And survivors are saying, we want something done to these people who are causing this harm to us. I cannot tell you how many clients I had when I had my own practice who would say to me, I just wish he would hit me. Then people would believe me. People would take it seriously. They were subjected to some of the most serious kinds of coercive control, but nobody believed them. And certainly, and I can talk more about this later if there's time, this became an enormous problem for them in their family court proceedings because judges were so focused on physical abuse. So I think there's an understandable push for criminalization from some survivors who want the validation. My argument, and I don't know whether you want me to get into this right now or later, is that they're often not going to get that validation, even if coercive control were to be criminalized. And so I think it's a false hope. And I think it's the job of those of us who may not have that lived experience, but have a lot of experience with how criminal law works and doesn't work, to try to talk about all of the downsides of criminalization, rather than just jumping onto the train and saying, okay, we need to do this because if we don't do it, it means that we're not taking coercive control as seriously as we take other kinds of abuse.
Great. Yes. Well, we will get into that a little bit more, Pam, and I think it's a great segue to moving over to you, Lee. And in your practice and in your work, how would you answer people when they say, well, isn't criminalization the best way to respond to intimate partner violence or, including coercive control?
So given that I've written a book called Decriminalizing Domestic Violence, I think you can kind of guess what the answer to that is going to be. And it's important, I think, for me to point out, as Pam does, right, that I come to this as someone who represents victims of violence and has done for almost 30 years now. I don't come to this as someone who is an apologist for people who use violence against their partners. But early on, as Pam described in my practice, I met clients who said, I don't want this system for my partner for many, many reasons. And I know that all of us who do this work have had this conversation. And so I started to look at the evidence behind criminalization, because as a lawyer going in and out of court every day, it was my intuition that the system wasn't working. And I wanted to understand whether it was or not. Over the time that I practiced and then wrote this book, I've come to really believe that criminalization does not decrease or deter intimate partner violence, that in fact it exacerbates many of the correlates of intimate partner violence, and that it's had serious, what people might call unintended, but I feel like we've known what the consequences are now for so long that we can no longer call them unintended consequences for the people that it was meant to benefit. And so just briefly, and with the caveat that my research comes largely out of the US context, but I don't honestly think that it's all that different. what the evidence shows about the effectiveness of arrest, prosecution, and incarceration is that they're not actually stopping intimate partner violence. If you look at rates of intimate partner violence in the United States over the period of time starting roughly around the time of the Violence Against Women Act in 1994 and coming through to the present, what you see, as our President Joe Biden will tell you, is a huge drop in intimate partner violence. What he doesn't tell you is that there's been a huge drop in crime, period. And that intimate partner violence has dropped about the same as the overall crime rate, notwithstanding the billions of dollars now that we've specifically put into criminalizing intimate partner violence in our system. So whether it's decreasing or deterring seems problematic as a measure. And then if you look at the social science research, what you'll see is that arrest does not deter intimate partner violence necessarily, that prosecution does not deter necessarily, and that incarceration does not deter. In certain circumstances, they can. Usually those require very close monitoring of someone so that they're not able to offend, and they don't look at the substitution of one kind of violence for another. So they measure repeat physical violence because that's what the law does something about. But they don't look at, for example, the substitution of emotional abuse or coercive control for other forms of violence that may be illegal. In terms of the correlates, just to give you two, because I don't want to take up all of our time on this conversation, economic distress is highly correlated with the perpetration of intimate partner violence. And economic distress is very much a side effect of criminalization. When you send someone to prison, they have a harder time finding work when they come out, even if they're not even incarcerated. Just the process of going through that creates economic distress. Similarly, trauma is highly correlated with the perpetration of intimate partner violence. And not only does the criminal legal system not do anything about the trauma that people have experienced before they use violence against their partners, it inflicts trauma on them as a function of being in the system and does nothing to ameliorate it. And then as to the kind of impact on those it was meant to help, if you look, for example, at the research on mandatory arrest in the United States, what you see is that after the inception of mandatory arrest laws that required police to make arrests anytime they had probable cause to do so if domestic violence had happened, rates of arrest went up significantly after mandatory arrest laws were adopted, not surprising. But they went up for one group more than anyone else, and that was women. Not because women had become more violent, but because of the way that these laws were being implemented. And it's important to note that that implementation disproportionately affects women of color. So for example, in the state of Connecticut, where there is still a mandatory arrest law, about 35% of the population is women of color. 35% of the population of women are women of color. 53% of those being arrested under mandatory arrest laws are women of color. So when you look at all of that data together, it makes it very hard to make a convincing argument that criminalization is addressing this problem. And Pam used a phrase that I think is really important, right? We are selling people a false sense of hope, a false sense of security when we tell them that the criminal legal system is going to end the violence that they're experiencing. And that's why it's so important to me that we're having this conversation.
Emily, can I just jump in and add one quick thing to what Lee said? And I don't know what the numbers are like in the United States, but here between 25 and 30% of women even report intimate partner violence to the police. So women are making that decision for themselves a lot of the time. Many different reasons, but for one reason or another, they're saying, I don't want to engage with that system. So we just keep layering on more and more laws, but women aren't even necessarily going to avail themselves of those laws because they already don't. And sometimes they don't because the system hasn't worked for them in the past. And often that's because they're racialized, they're indigenous, they're poor, they're trans, they're sex workers, they have mental health issues, or they're substance users.
And those are all the people that I call imperfect victims. And anyone who is an imperfect victim who tries to go through the system and get assistance finds themselves kind of stymied at every turn. And our numbers, Pam, are about your numbers. They're certainly less than half. So when we say, well, what will we do if we don't do criminalization? 2/3, half to 2/3 of women are doing something else already. So we need to figure out what that looks like and how we can resource that properly and how we can build those systems that respond to people outside of the criminal legal system.
When you talk about imperfect victims, I think you say this in the book, but certainly my experience is it's not just those women who fit into a category. It's also women who demonstrate anger. who don't do what we think a victim should do, who don't come into the court process cowed and fearful and submissive, but who are mouthy, who
Yep.
are angry, and those are also imperfect victims who can be really harmed by the criminal response.
Yeah, so one of the things, I think one of the problems of the early understanding of intimate partner violence based on Dr. Lenore Walker's work and the battered woman syndrome was that it gave us this picture of a meek, weak, passive, also white, straight, cis, abled, person who was not going to respond in any way to the violence against her. And that's why it was so important that the system had to respond. And so if you depart from those norms, if those stereotypes in any way, you're an imperfect victim. And it's not just kind of mouthy and angry, it's also anybody with agency. So you'll see judges say things like, well, she has a job, so she can't be battered. She has a checking account, so she can't be battered. So it's really the path that you have to walk to be considered an appropriate victim is so very narrow that almost no client I've ever had could safely walk that path.
I couldn't. Probably you couldn't, and probably you
Oh,
couldn't, Emily, either.
way too mouthy, among many other things.
It's a really wonderful thing when the job of the moderator is to just listen. So, you know what, feel free to just keep talking and I'll just prompt you where I think there are some questions and the direction that we might want to go in. But I did want to,
Emily, I want
yes.
you to jump in because you know more than either of us does about the general state of criminalization of women in Canada, not just survivors of IPV. And I think that's an important part of the conversation too.
It certainly is. But before we go there, I will talk about that. I wondered if we could come back a little bit, Pam, to what you said at the very beginning. And because I really don't want people who are listening in, particularly people who are listening in who don't often turn their minds to criminalization and the impact of criminalization on the people that they work with. For some people, this is a really new conversation or thought to be having. And so we really wanted to include you in these conversations because the soup that we swim in essentially is, yes, we have the criminal law, and the criminal law indicates what we, are going to criminalize, and that's good. And the systems are working. And we all sort of assume the systems are working until we work in those systems or the systems impact us. And so I wanted to get back to one thing that you said at the beginning, Pam, which was that survivors of coercive control say they feel ignored and disbelieved, sometimes because there's a lack of criminal law that describes this kind of abuse. So what should we do about that? How do we listen to what survivors are saying about that?
Well, we have to listen to survivors, absolutely. And I think when we have this conversation, we have to say, we get it. We totally get that you often feel that what's happened to you isn't validated or isn't taken seriously, but there are other ways to do that. And first, here are some of the pitfalls of creating a criminal offense. First of all, what if a woman who has been subjected to coercive control, now there's a criminal offense, she calls the police, and the police are not well enough educated? It's a difficult offense to charge and to prosecute. A slap across the face leaves a bruise. It's a moment in time. It's an incident. And criminal law is incident-based law. It doesn't look at patterns of behavior generally. So she's going to call the police and say, over the last 10 years, he's done this and he's done that. And the police officer is going to say, well, what am I going to charge here? You don't have a single incident to point me to. And I say that with all due respect to the police who have a difficult job to do. But historically, they've had trouble figuring out physical abuse. This is difficult. So how is that validating for her? If that's why we're making the law, to help survivors feel validated, and they call the police and no charge gets laid, that's not validating. What if the Crown declines to prosecute? In Canada, Crowns are under a lot of pressure to only prosecute where they think they're going to get a conviction. These are going to be tough cases to get convictions in. So how's that going to validate her? If the judge hasn't been properly educated, which is an enormous problem, is the judge going to understand the evidence that is put to them, and is going to think, not just on a balance of probabilities, but beyond a reasonable doubt, that this person has committed this offense. So I think we start by saying, let's break down that criminal system and look at all the ways it might not validate you. Then let's look at the ways it could be used against you. Abusers got very good at using mandatory charging or mandatory arrest policies against women. Of course, they're going to do the same thing here. So she's going to be charged. And then that leads us into, another part of this conversation today, and that is the impact on her family law proceedings if she's the one facing criminal charges. Then we've got to offer her alternatives. But I'm going to stop there by saying I think the beginning of that conversation is to say the criminal law isn't as great as you think it is. And in this instance in particular, here are a number of ways that it might not give you what you're looking for. We'll work with you to get you what you need, but this isn't the way to go. You're muted, Emily.
Modern technology. I do hope we will get to some of the examples that you have in your book, Lee, because I found them to be really helpful in terms of the storytelling aspect of how this can affect people's lives. And I will speak a little bit about the Canadian context and the reason why our organization exists. And it exists because we have recognized over the years that the carceral continuum in this country is really failing a great number of people. And those people are the people who are made the most vulnerable, made the most marginal by the systems that they interact with, beginning often with childhood, with the child welfare system, the healthcare systems often. The healthcare system leads, also to education systems, and then there's policing, prisons, the courts, etc. So these are all systems that the people that we work with often interact with, and they are often criminalized. And so in Canada, we have a problem of mass incarceration of Indigenous peoples. In our federal prisons designated for women across the country, where our organization monitors conditions of confinement, the numbers are shocking. And, for us, having 50% of the people in the prisons designated for women are Indigenous, when they only represent 4% of the Canadian population, is shameful, and also indicates a huge problem that doesn't begin at the prisons. It begins way before that. And it begins with things like, what are we criminalizing? How are we criminalizing? And who are we criminalizing? And so if we then go to the provincial jails, which is anybody who's serving time less than 2 years, or anybody who is on remand, which is pretrial detention, which means they haven't actually been convicted of anything yet. Those prisons are in Canada, those jails are often over a capacity by a mile. And a recent figure that I saw in Ontario, for example, is that 80% of the people in the provincial jails are on remand, pretrial detention, which means they haven't been convicted of anything. People are dying there at alarming rates that nobody is hearing about. And often the people in those prisons are Indigenous. And if you go into some of the locations across the country, it is 90 to 100% Indigenous in those provincial jails. So we are already criminalizing Indigenous people in this country at high rates. But we also criminalize Black folks. We also criminalize trans folks, sex workers. There's an intersectionality here that we need to be talking about. Intersectionality is not just a ephemeral concept. It actually means for a lot of people that their lived experiences lends to becoming much more criminalized. So if I'm a Black trans sex worker, for example, I'm much more likely to end up being criminalized because my life is overly surveilled by various systems. And so, we're very concerned at our organization over the years that increasing criminals' responses is going to continue to criminalize the people who are made the most vulnerable and the most marginalized in our societies. And shouldn't we be, instead of responding after the fact, shouldn't we be doing as much as we possibly can to prevent harm from happening in the first place. And I think that's where we will be going in the later part of this discussion. And certainly, you know, we also think about, because I see some folks who are here from the immigrant and refugee serving side of things, we also think about how immigrant status impacts criminalization and the dual punishment of potentially being deported if you do end up being criminalized for something. And we have our friends at the Schleifer Clinic. You're not familiar with them, Lee, but they work at the intersection of folks who are potentially precariously status in Canada and criminalization, and see how dual charging, for example, where police go to the house and they charge both parties, can lead to people being deported from Canada, and not the people that we imagine, right? So when people are imagining creating a new criminal offense, they imagine that they are going to be protecting the most vulnerable and the most marginalized. But our caution is always, well, that's not what happens. In our work, we see that those are the people, as you said, the not so unintended consequences, because we already know now, we've seen it for years and years, that those are the people who end up being harmed by increasing criminal responses. And so Pam, I'm gonna come back to you again. We've touched on this a little bit, and maybe you could give some examples. And actually, Lee, if you could give some examples as well. If we were to criminalize coercive control, because we do have current criminal laws that apply to domestic violence or intimate partner violence, how could this be used against survivors? And if you could give some stories and some examples to illustrate, that would be great.
Lee, why don't you jump in first? I've been talking a lot.
It's fine with me either way. So I think it's pretty clear that, just kind of building on what Pam was saying, we'll have police who don't really understand the offense. And you can say training until you're blue in the face. I will tell you that my job was training judges for 3 years. And what I learned from that is that judges who are interested get trained and judges who are not interested don't. And it doesn't change the way that a whole system works. It doesn't change all of the dynamics of that system. But we'll have police who are undertrained. They'll show up at the scene, and one person will say, well, he has been monitoring my whereabouts, and he has been, you know, doing various things to me. And the police will say, well, that doesn't seem like it's enough, right? So because there won't be a bright line that says, if you have 3 different elements, right, that will be enough. It's going to require police to use discretion in ways that police aren't particularly good at using discretion. And I do want to pick up on Pam's point. They can't do, and at least in the States, many of them can't do physical abuse. You have a bruise, but that bruise can be explained 100 different ways. He said, she said, we're not going to arrest anybody, right? And so, I mean, again, like, title of the book is Abolition Feminism. I don't actually believe in arresting people and convicting people, so that's a whole other conversation. But let's be clear about what the police are and aren't capable of. My bigger concern is when a person who has been abused by their partner for years, the police come to the home and the person who's been doing the abuse says, well, she calls me every 5 minutes to see where I am, and she texts me incessantly, and she tells me I'm not supposed to see other women, and she tells me that she belittles me. And look at all these texts I have where she's bothering me all the time, and look at all these phone calls I have, and look at where she calls me names. I am being coercively controlled, and you need to lock her up. So, you know, part of the beauty of coercive control is its flexibility, in that it enables us to bring in evidence of lots of things that don't necessarily look like abuse on their face, but when put together and put in a particular context, are incredibly damaging, are deeply damaging. But the problem of creating a crime of coercive control is that that same flexibility can be used to wrongly characterize things like, I was told I had to check in every 10 minutes, or there bad things were going to happen to me, but we don't have that in the text chain. We just have, I'm texting you, I'm texting you, I'm texting you, I'm calling you, I'm calling you. The potential for misuse of a crime of coercive control, I think, is so overwhelming. And we already have story upon story of survivors who say, I fought back. One time I fought back. For all the hundreds of times that I've been hurt in some way, I fought back. And it's that one thing that the police seized on. I think we're going to see coercive control misused in the exact same way. And then, if you look at the studies on credibility and who is deemed credible by law enforcement and by judges, it's not women and it's not people of color, and it's certainly not gender nonconforming people. And so when those people are trying to say, that's not how this happened, those innate biases, those unconscious biases, and then those conscious biases as well, are going to play out so that one party is deemed more credible than the other. And so I have real concerns. We've already seen how the law gets misused against victims. We see it all the time. We see it when people who fight back in self-defense are criminalized, and we see it when people who act under duress are criminalized, and we see it when people who are self-medicating or committing other crimes because of their abusive partners are criminalized. This won't be any different. And in fact, I think it'll be worse because of that flexibility that's inherent in thinking about coercive control. And, I think, one response to that might be, yes, but if we actually used Stark's conception of coercive control and required some showing of a limitation on liberty or autonomy in some way that's tied to all of this behavior, then maybe we would get around that. And again, I would say it all is going to come down to credibility. So if someone says, well, I have felt fear, I have not been able to live my life out the way that I want to live my life out because I am concerned about what this person might do. And look, here are all the texts and here are all the phone calls. I just don't think that our system is equipped to do the kind of nuanced, sensitive, non-incident based, as Pam said, determinations that are required under this law. And, just to take it one step further, think about in your own work when you're trying to figure out if somebody's being coercively controlled. That, for me, as a lawyer, takes multiple conversations and finding documents and getting records and really digging in to be able to prove up that case. Police on the scene aren't going to do that. And so at what point is that getting charged, right? Someplace down the line, maybe? Who knows?
And even with all of the work that is involved for you, say, as a lawyer, representing someone who's telling you they've been coercively controlled, you're starting from a place where you believe her. You're starting with that background. You're bringing a trauma-informed approach to it. I want to kind of react to three of the things you said that I think also answer the question that Emily posed. If we truly believe, as I do, as you do, I think all three of us do, that we should stop criminalizing intimate partner violence and maybe everything else too, but that, as you say, Lee, is a conversation for a different day, then we just have to stop, right? Yeah. Like, let's stop adding more and then we'll deconstruct what's already there. So it seems like a foolish time to add a new offense if we mean it when we say this system is broken and we need to find a different way. I think the flexibility that you talk about that's so troublesome in criminal law is why, in Canada anyway, it's important that the Divorce Act now includes coercive control in its definition of family violence, because family court is looking at at the issue from a whole different perspective. They have a different standard of proof. It's not about finding somebody guilty or not guilty. It's about making a plan for this family as it moves forward in its new construction. And there you are not focused on incident-based issues. You're looking at patterns of behavior over time. What's the parenting pattern here? Who's really been the one taking care of the kids? What's the abuse pattern? And so to say it's not a good thing to criminalize coercive control, I don't want anyone to think that means we shouldn't be talking about it or that it doesn't have any place in law.
Yeah, agree. 100% agree.
Ontario has a program called the Family Court Support Worker Program that I'm very involved with as a trainer. These are non-lawyers who have a background in violence against women work, who provide women with support through their family court journey. And every year we bring them together for a conference. Several years ago, we were talking about the impact of mandatory charging on the women they were serving. And it's an anecdotal report, but what we heard absolutely substantiated what you were talking about, Lee, in terms of what happens when women get charged. Women are being overcharged. Something they do that, if it resulted in a charge at all, had a man done it, might have been an assault charge for a woman, winds up being assault with a weapon, and with virtually no consideration of the context. So we just asked the workers in the room, there were about 60 or 70 of them, how many of them routinely worked with women who had been charged, and pretty much every one of them put up their hands. We said, okay, so what was it they did? And it was usually, not always, it was usually in the course of some kind of confrontation between the two partners. They had been charged, these women, with assault with a weapon for things like throwing a baby bottle nipple across the room that glanced off the partner's head, a stuffed toy, a diaper. I didn't investigate the state of the diaper, right? But a banana. Now, maybe none of us should ever throw anything at anybody else. I don't want to get into that conversation, but these were not weapons. These were not worthy of charges at all, let alone charges that elevated the seriousness of the consequences to the accused. And in every case, the abuser could not wait to raise that issue in the family court proceeding, despite the fact that she had a mountain of evidence, which largely was her story, of what he had done to her. So there's absolutely no reason to think for 1 second that a crime of coercive control will not be used against those who are the victims and survivors of it, because the pattern is well established.
Right, we've seen it with protective orders. We've seen it with mandatory arrest. We've seen it with every other innovation that was designed to be victim-centered and victim supportive. People figure out how to misuse those things, and they do it actively. And so, and then kind of what that feeds into is then kind of what women are willing to do to try to deal with that. So women are much more likely to plead guilty, even to things that they didn't do, so that they get home to their children, so that they can kind of do what they need to do in their lives, because they are more likely to take responsibility for throwing a diaper or for throwing something than some men are for throwing a fist. There are lots of reasons why women are more likely to plead, but the social science research very much bears this out. So once you start down that road, this thought that, oh, well, even if there's a bad arrest, it'll get sorted out in court, is not what's actually going to happen. What's going to happen is, like the vast majority of cases, women are going to plead guilty. And then they're going to walk into the family court with that conviction. And that conviction will doom them in family court. It's certainly true in the US. I would imagine it's probably true in Canada as well.
Absolutely true.
And so then you lose your children as a result of that phone call. You lose your right to any kind of support as a result of that phone call. You may lose property rights as a result of that phone call. It's really devastating. And so before we kind of rush headlong into this very malleable crime, I think we want to think really carefully about how it can be misused.
One of the other things that happens when women go to the police, because if you're born and raised in Canada, that's what you're taught. You know, when you're in trouble, you call that nice police officer to help you. So when women do take that step and they have a bad result of the kinds that you and I have been talking about, they don't call the police the next time, when actually they need to, in the sense that they need somebody to intervene immediately. We need a system other than the police to do that, but you know, to keep them safe. So they expose themselves to ongoing and increasing levels of risk of serious harm, because they think, well, that didn't work the last time, why would I try that again? Good thinking, but maybe this time he's got a knife at her throat.
Yeah, and it's important to kind of, the backdrop for a lot of this conversation is something that the criminologist Mita Chesney-Lynn called vengeful equity. So at the time that a lot of these innovations were being developed, people said, oh, women want us to be intervening in this way? Well, we will absolutely intervene in this way. And so if you want the law to say this, then you better be prepared for it to be used against you. And so part of what drives that increased operation of the law against women is this idea of, you want to be equal? Oh, we'll show you what equal looks like. And, you know, for us in a country where police officers are committing acts of intimate partner violence at rates highly disproportionate to the general population, you know, query how exactly that gets imposed.
And that's also true here. That's not my research, but Battered Women's Support Services in Vancouver has some pretty damning evidence about rates of domestic violence by police officers.
And it is interesting too, because we are up against, biases about gender and, how the gentler sex, and if people do end up defending themselves, or as we said earlier, speaking loudly, then they're often punished for that at higher rates, or overly punished, as opposed to the men who might be in the same situation. I have a couple of questions to ask you that have come from people in the audience. But before we get there, I just wanted to know if we wanted to continue to explore some of those other issues that we had discussed before we came on here. So Pam, do you feel like we've explored enough about how criminalizing coercive control could be helpful or harmful to a survivor's family law case? I mean, you've touched on it already. Is there anything else you wanted to say?
I do just want to make a couple of other quick comments, because I've mostly talked about the harm to the woman's family law case if she's charged. But what I also want to mention briefly is that if the abuser is not charged, so now there's a crime of coercive control, she reports it to the police and they don't charge him, or she doesn't report it to the police because she's too afraid to. She has a family law case. She talks about the abuse that's happened in the relationship. And I can promise you his response will be, well, I'm not convicted of anything. So, I mean, we come up against this all the time, not just in the family law context. Can we say that a woman was a victim of intimate partner homicide if the partner isn't ultimately convicted of the homicide? Because we're defining guilt or responsibility by a criminal conviction, we just narrow the reality to something that's not reflective of the truth. Women don't report to the police for a million reasons. But if there's a law that judges think, oh, she should be using that law, she didn't use it, then obviously that means it's not true. That is going to create difficulties for her in her family law case. And I think that's the main point I want to make, in addition to the comments I made earlier.
And one of the things that comes to mind as we're working through these questions is that we're assuming that the people who are, and we did talk a little bit about immigration and immigrant status, but what if English is not your first language? What if you don't have family support in Canada? What if you're alone with your partner and your children? All of these factors.
What if you come from a country where the police are, blatantly corrupt, I guess is the way I would put it, or where there are no laws at all related to intimate partner violence.
Right. And so when we're imagining, the criminal offense of coercive control, certainly legislators and others who believe that it is important to criminalize this might be thinking, well, this will be, something that will protect those people. But in fact, we have to think about what is actually happening on the ground. And it could potentially be much, much worse for someone in that situation. But we also come to this question around accountability. Shouldn't people who cause harm be held accountable? And I query the word accountability, because what does it mean to be accountable? And why are we wanting to hold people accountable in very specific ways? Why is having a criminal record or going to prison or jail the form of accountability that we are seeking? And, I think some of the answers lie in the fact that we haven't had alternatives. We've continued to see that as our only solution, and to put all of our efforts into the solution that exists that is not working for everybody else. And so the purpose of having this panel discussion is not only to poke holes in that, but also, I think, to have some discussion around what could be if we weren't putting all of our energy into trying to fix or ameliorate the current system. And so, Lee, I'll turn it to you there. What do you think some of the alternative responses could be?
So summarizing 80% of a book in about 3 minutes,
Yes,
So
thank
this
you.
is
No,
what I lay out in
everybody
decriminalizing.
do
Another
buy
book,
it,
actually,
do
it's
read
better
it.
for that one. But what I've done in that book is to argue that we actually could look at this as an economic problem, as a public health problem, and as a community problem, and have very different kinds of responses. So as an economic problem, thinking about the fact that economics is highly correlated, again, with the perpetration of intimate partner violence, how do we get people to an economic security that helps to alleviate some of the stress and some of the trauma that people are experiencing so that they are no longer in a position to offend? And so, I know that, the answer is, well, it happens in high income families, and it does, but it happens way more in low income families. And the social science bears that out. So thinking about things like a living wage and a guaranteed family income and appropriate housing for people, like how do we make sure that people have the things that they need, not just to live, but also to thrive, so that they are not they're not experiencing this stress. And so in the United States, we've talked about increasing the minimum wage, and we've talked about guaranteed family incomes and a variety of different programs that might deal with that. But it's also a bigger structural issue around, capitalism and neoliberalism and lots of things that in the next 7 minutes we're not going to really get into. But it's important to recognize that this isn't just an individual conversation about getting this one person more money. It is about the ways that society is structured and the inequities that are baked into our societies and how we deal with that. In terms of public health responses, as Emily said, right, prevention has to be a huge part of what we're doing, and it's prevention along a number of different dimensions. So it's prevention in thinking about how do we get to kids at an age that's early enough for them to really learn what good relationships look like, what healthy behavior looks like, to intervene even earlier than that. If you look at, for example, nurse practitioner programs that go into homes after people first have babies to try to deal with some of the huge amount of stress that comes with having a new baby in the home. And that works, they show lower rates of intimate partner violence when you have somebody in the home who's able to provide that kind of support. How do we do meaningful work around accountability? What criminalization does is passive accountability. This is from Danielle Sered's book. You sit there and you don't necessarily have to reckon with what you've done, but there are active ways to hold people accountable in ways that might help them to change. We've done a lousy job, I think, with offender intervention programming. That's a whole nother conversation, but we've just done a lousy job with it. And it's not really working in the way I think that we want it to, but it could. And one of the ways that it could is if it had actually acknowledged two hard things at the same time, that people have experienced trauma and that they are inflicting harm on others. For years, as a feminist community, as an anti-violence community, we have been unwilling to talk about the trauma that people who use violence against their partners have experienced because it felt like an excuse. It is not an excuse. It is an explanation. And if we don't pay attention to that explanation, we will never get to the root of why people are being violent in the first instance. Then we have to think about community. Again, Pam said, right, most people who experience violence not going to police. So what are we doing for people? People are finding in their own communities what they need to be safe and to feel safe. How do we resource that appropriately without necessarily bringing the state into it? And part of that is restorative justice, but I always feel like I have to use a huge caveat here, which is that restorative justice is not going to replace the criminal processing system that we have now. About 600,000 incidents of intimate partner violence in the United States. You're not going to put restorative justice in to deal with all of that. It's not going to happen. But it can be a really small part and an important part of an overall strategy that makes communities accountable for holding people accountable, that brings communities in to say, you can't do this, and we're going to help. We're going to help by providing you with things that you need to be nonviolent, whether that's a couch to stay on when you feel yourself getting angry, or a check-in accountability partner, looking at the research on circles of support and oh, I just lost the word. God bless menopause. There are these circles that people use that involve both professionals and lay people to provide support for people. So there are so many things that we could be doing that don't require the intervention of the criminal legal system at all. And we could be rethinking how first responders work. So I agree with Pam wholeheartedly. The reason that people call police is because we don't offer them anything else. The reason that people want the criminal legal system is because we don't have anything else. So we have to develop those resources. What could it look like for violence interruption programs and anti-violence professionals to work together to be the first responder, as opposed to sending in an armed person who may have de-escalation training, but doesn't seem particularly inclined to use it in any kind of meaningful way, right? And who understands the dynamics that we're talking about, so that we don't end up with victims coming into the system because somebody's got a scratch on them, because somebody doesn't speak English and can't explain what happened to the officer who happens to show up. There are so many things that we could be doing other than adding crimes to the pantheon of crimes that we already have. And they would be such better uses of our time and our resources.
It's always just seemed to me, it just doesn't make sense that we talk about the criminal system as though it offers accountability. When in fact, it's constructed to do the opposite. If
Right.
I'm charged with a criminal offense,
Right.
like I'm not a survivor who's been charged, I've done something bad, I've been charged with it, there's no incentive for me to be accountable. In fact, the
Right.
incentive is for me to deny that I did it. And because we have an adversarial system that says the Crown Attorney has to prove beyond a reasonable doubt that I did it, I don't have to prove that I didn't do it. Accountability has to happen outside that framework, where I can reflect on what I did. I can say, yeah, I did that, and here are some of the reasons why. And Lee, you've elaborated on those really articulately. And then I need to know what harm it did to the person I harmed. So she has to, or they have to, feel comfortable and safe and empowered to share that. And then we get some accountability. When I heard you speak at a conference a number of years ago, Lee, you did this. You said, here's two people who maybe start out kind of equal, and then there's an act of violence, and this person, the victim, is lowered down in her capacity and her strength. And then we bring in the criminal system, and all that does is also reduce the person who caused the harm. It causes more harm to that person. And instead, we need to be looking for a system that lifts her up, and in fact lifts them both up from where they started. I hope I got that right, because it's been really a powerful image for me ever since I saw you do it. And I think it's absolutely right. This is what we're doing. We're trying to equalize by lowering them both, instead of maybe equalizing by raising them both up.
Which is a reminder around, some of the restorative versus transformative justice conversations that we've been having. We are 1 minute away from the top of the hour, everyone. And this has been a wonderful conversation. There are some questions, circles of support and accountability.
That's it.
And then so Nadine asked if we're located in Canada or the US. We're in both. Lee is in the United States and Pam and I are both in Canada. There's some comments here. Oh, Tara Borden, Pam, where can I find information on women being charged with assault with a weapon more often than men and DV incidents?
I'll have to get back to you, I guess maybe through CAEFS about that.
Yeah, why don't you email us? Sure,
Yeah.
if you have that question, and we will get that to you. There's some other comments there that I don't think we're going to get to because it's 1 o'clock, but I do thank everybody. We'll take a look at these and see if we can respond in some other way. I want to thank everybody for joining us today. It's been a rich conversation, and a conversation that is necessary to have to question some of the systems that are currently in place and look at how we can actually, respond to the crises that are existing in our community. First, I would say by going upstream and providing as much supports as possible at the outset to prevent harm from happening in the first place. However, if harm does happen, then we need to be looking at how we are addressing that harm, and how we can prevent people from being harmed by the very systems that are supposed to be protecting them. So I just wanted to thank you, Lee and Pam, for this wonderful conversation. I'm sure we could continue to have much more time to unpack a lot of this, and hopefully it was helpful for the rest of you who attended today. I wish you all a wonderful day. Thanks so much. Bye, everyone.
Thank you.